We will look at the differences between schemes of arrangement and reconstruction. So a scheme of arrangement involves the reorganization of the share capital of the company by consolidation of shares of different classes. So reconstruction will involve the selling of the assets to a company for partly paid up shares. A scheme may be sanctioned by court, but a reconstruction is sanctioned by the resolution of members. In a scheme, we have the settlement of the dispute by mutual consensus, but a reconstruction will be carried out by the company that is to be wound up voluntarily. For a scheme also, the company may enter into arrangements with its creditors or any class without going into liquidation, but a reconstruction will be made by another company by transfer or sale of its assets during liquidation. So a scheme operates under Section 280, but a reconstruction operates under Section 201 of the Companies Act. Section 280 talks about the powers of the liquidator to accept the shares as consideration for sale of property of a company. And it provides where a company is proposed to be or is in the course of being wound up voluntarily, and the whole or part of its business or property is proposed to be transferred or sold to another company, whether a company within the meaning of this act or not, with the sanction of a special resolution of that company, conferring either general authority in respect of any particular arrangement, any sale or arrangement shall be binding. Again, talks about voting, and Section 201 is what we had talked about. Not 201. We're talking about Section 208 to 210 for the reconstruction. And these provisions power to acquire shares of shareholding dissenting from a scheme or contract approved by the majority. This is what we had talked about, where if any shareholder feels that their rights have not been catered for, provisions for facilitating reconstruction and amalgamation of companies is under 209, and we had talked about the application made to the court under Section 207 for the sanctioning of a compromise or arrangement. So the Companies Act will provide these provisions. And we had talked about amalgamation being synonymous with mergers. And that is the combination of two or more, either into one, or one becomes a subsidiary of the other. So they blend together. And once they blend together, the shareholders, if it's for the new one, then become shareholders of the new one. If it is for, if one maintains and they become the subsidiary. is where they will have group accounts. And the provisions of the Companies Act will still apply to them. So we have three forms of business combinations. Four forms. We have a statutory merger, and this combination results in the liquidation of the acquired company's assets and the survival of the purchasing company. One entirely stops existing, while the one that acquired, when they came together, we had Company A and Company B. Company B remains, Company A is wound up so that Company B is retained. Statutory is under the law. The shareholders went to court and proposed or gave that special resolution for that company to be wound up. Company B again went to court and proposed to, so to speak, swallow or retain and take under its, take company A, such that Company A does not exist anymore. So the court orders, and the order of the court now becomes binding. And the assets that were acquired no longer sees we had an office building under Companies A's names. These ones are sold off and proceeds go to B. So A stops existing. B now maintains every other aspect of that business organization combination. We have a statutory consolidation. We have Company A, Company B. None of them, and we will have now Company C. So Company A stops existing, Company B stops existing, and now on the records we have Company C. We have registered it afresh. We have a certificate of incorporation. We have a register of members. We have a register of the board of directors. So A and B, again under the court, stop existing and C completely takes over. We have a stock acquisition, and this is where it is a business combination in which the purchasing company acquires the majority. That is more than 50% of the common stock of the acquired company, and both companies survive. For this is where we will have now a holding company and a subsidiary. Because the holding company, when you acquire more than 50%, you acquire the controlling interest. So whatever Company B does cannot go against the wishes of Company A. Company A runs the show. Company B continues. We talk of the subsidiary cannot go beyond what the holding company intends it to do. It may act in as far as this with the 50% plus. It acts as far as the ones controlling will enable it to do so. And this is what we mean by stock acquisition, in that they can make decisions that can adversely affect the subsidiary. They're the ones who control how that subsidiary will be run, whether it will have branch offices or whether it will only remain under the holding company. We also talk of now that amalgamation, a merger. an existing company, that is the vendor company, is taken over by another existing company, and consideration is paid in cash or in kind. When we mean in kind, we take shares. You give us this amount of shares in order for you to acquire stake, or we pay off your creditors, we pay off any other issue that may arise. And the purchasing company survives in this process. So essentially, when we talk about reconstructing, corporate reconstructing, there are two companies. Their interests may be diverse or they may be similar. They may be carrying on the same nature of business. One company is struggling, the other company is not struggling. Or in some instances, no company is struggling. But one company has the means, asset-wise, technical-wise, and their interests may not be to give the other company a chance. It may want to eliminate competition. And the only way it can eliminate competition is by owning, controlling shares, what we have talked about, 50%, such that they still get the profits. You continue operating. If it's a brand name, the brand name continues, but the books of accounts show who the owners are, who is getting the benefit from that company continuing to exist. So we have takeovers, we have mergers, we have and the takeovers, how they are done, as well as what we have talked about, the mergers, statutory, consolidation. Basically, it means changing the face of the company from what it was to what it will be in the future, once the court allows such an arrangement or a scheme to be done. And with that, we will have covered corporate restructuring. These are the past paper questions that relate to chapter 14. So why do we restructure? And the reason why companies restructure: one, adding acquisition of more assets, the payment of debts, acquisition of technical know-how. There's also the element of acquisition of the ability to expand.